The Supreme Court strikes a blow for business versus the administrative state. SCOTUS got busy at the end of its current term, and there were many major decisions. We spoke above about the ruling on presidential immunity. That was probably number one. The other big case was striking down of the Chevron doctrine. For a business in America, dealing with administrative agencies can be very challenging. The agencies create the rules, enforce the rules, and then their paid employees adjudicate disputes over possible violations of the agency rules. If a business is unhappy with the outcome, after exhausting all the internal steps, it can go to court. This is an extremely costly and time-consuming process. Most small and even fairly large businesses cannot afford to fight. Even if the businesses can get to court, the battle's not over. The reason is something called the Chevron doctrine. This is the result of a SCOTUS ruling in 1984 in the case of Chevron versus the Natural Resources Defense Council. The court held in that case that it was appropriate for the courts to defer to the expertise of the government agency when facing an appeal of an agency decision. This is the infamous placing your thumb on the scales of justice, and it was never right. It should never have happened. That's what we call judge-created law. Fortunately, in a massive change in direction, by a 6-3 decision, the conservative majority of the Supreme Court ruled in Loper Bright Enterprises versus Raimundo, Secretary of Commerce et al. And the justices voted in favor of striking down Chevron. Frankly, I knew this was coming for a while, and it couldn't happen too soon. Chief Justice John Roberts stating, regarding the majority opinion, courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. The agency flunkies are not trained to make those statutory interpretations. So Roberts, of course, didn't use the term flunky, but that was the implication. Paired with this decision, that said someone accused of a serious charge like fraud was entitled to a jury trial. This would mean the administrative agency would not have the last word. It used to be if you were in front of the Securities and Exchange Commission, you didn't have an opportunity to have a jury trial, and the courts have corrected that concern on constitutional grounds.